So today I want to drop an absolute bombshell on you, exposing that certain Aquaman starlet's key witness as a fraud to the point that they involve themselves in high-profile cases while admitting they testify knowing nothing about said cases other than what they've read in the media. They can provide you an overview, perhaps, but really, they don't know anything about the cases at all. Now, this was so bad, in fact, in other cases, and I would argue in the case for JD versus that certain Aquaman starlet as well, that she has been removed from them. Why? Because she was transmitting inadmissible hearsay statements to the jury, and she was also testifying about irrelevant and unduly prejudicial conduct in cases that have no factual connection to the case at all. Sounds exactly what we heard from her when she took the stand too. See, essentially, Dr. Dawn Hughes has been labeled by others as a clout-seeking, quote-unquote, expert bully for hire who testifies in high-profile cases, like, say, the R. Kelly case, in the case against the Catholic Church, the Boy Scouts of America, the NXIVM cult, and, well, anything that will get her clout. Anything that will make her money, but she doesn't know about those cases at all. Myriad filings put her on blast for this too, calling her out again as a bully for hire, a clout seeker, somebody who doesn't know anything about these cases whatsoever. Again, they'll talk about the Boy Scouts of America, the Catholic Church, USA Gymnastics, NXIVM, the cult. You could also have R. Kelly, but do they know anything about the cases? No, not at all. Now, the background on this particular filing, I thought that this was fascinating because the court, they initially denied this person that's filing it their motion to preclude their testimony in its entirety, but they reserved decision on the full scope of Dr. Hughes' trial testimony. They're going to decide whether or not this means anything at all. Now, the argument, compare this to what they bring to the JD case, and I'll show you in other cases how they have admitted that they bring nothing whatsoever, but the argument for the legal standard, pursuant to Federal Rule Evidence 703, if the facts or data upon which an expert relies in forming her opinion are otherwise inadmissible, the expert may not disclose the facts or data to the jury unless the court determines that, quote-unquote, their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Now, a very important distinction when it comes to expert testimony is this, quote, expert testimony that merely recites inadmissible hearsay is improper, or finding expert opinion inadmissible when it, quote-unquote, amounts to nothing more than admissible hearsay in disguise. Now, we'll return to that document in just a moment because it absolutely devastates what she brings to cases. But as far as inadmissible evidence is concerned, which we heard a lot of, and I do mean a lot, with JD versus that certain Aquaman starlet, well, this is apparently her norm. Here's a report on another case. Listen to how this is described. Quote, cross-examination was brief and uneventful. Called to the stand next was Dr. Dawn Hughes, a psychologist. She's worked in 20 years in the field. She's a PhD, a clinical and forensic psychologist. She specializes in interpersonal violence and traumatic stress. She's worked in different settings and is board certified in forensic psychology. She is one of only 375 board certified members in the U.S. in her category. She testified that she has no knowledge about this case other than reports she read in the media. Again, drink that in. No knowledge about this case other than reports that she read in the media. So you could be just as informed as she is on this case that they're talking about. She offered an overview, not based on anything that she knew about the case. Again, you saw the same thing that happened with JD versus that certain Aquaman starlet. She gave overview. She gave it for over an hour. And again, what did that bring? Inadmissible hearsay. Now, as far as inadmissible hearsay is concerned, you have Dr. Hughes called out for this again and again, myriad court filings. And listen to this one. You tell me if this is exactly what you heard play out with JD versus that certain Aquaman starlet. The court should preclude testimony from Dr. Hughes that improperly transmits inadmissible hearsay to the jury. Dr. Hughes' trial testimony in other matters, so they're quoting other things plus this one, frequently recounts to the jury hearsay anecdotes of unidentified victims of interpersonal violence, alleged abuse by unknown perpetrators, relates how those unidentified victims describe their experience and how they process these incidents, and reports how the unidentified victims said that they felt in those circumstances. This testimony, it frequently repeats statements that Dr. Hughes has heard from her clinical patients. Again, you heard that. You heard it time and again on the stand for hours. That's exactly what she does in every case. Now, the problem with that isn't necessarily her reliance on that type of material, but rather the biasing effect when you pass that on to the jury, especially when you consider the probative value. Does it have any? And well, that's brought up again, not just in this, but it's brought up many times. Listen to this too. It sounds like a cut and paste job when you're describing JD versus that certain Aquaman starlet, because this person, all they do is come in time and again, drop the same types of information because they're a bully for hire, one that has been called out as a fraud again and again. Quote, on the other hand, the probative value of such anecdotes is minimal, if exists at all, and is certainly not essential to the purported subject material opinion testimony Dr. Hughes is going to offer based on her training and on an extensive study of empirical data and on social science literature on certain types of assault, on IPV, victimization, coercive control, and trauma. Again, you bring her in every single time. She recites the same type of testimony. That stuff, it biases juries, and you've had judges say, yeah, you can't do that. You can't do it at all. Now, from what I'm reading, she's actually had testimony removed from cases. Why? Because she creates prejudicial effects from something else. I mean, think about this. She doesn't know her cases, so what does she need to do? She needs to convince you that she's been on other high-profile cases. Now, if I start bringing those up, and she did in JD versus that certain Aquaman starlet, what happens when I bring up the Boy Scouts of America? What do you think about those claims right there? You think about things that have nothing to do with this case. She's been on a lot of cases like that. Huge clout seeker, as other items have showcased. She'll bring that stuff up time and again because it's an ego boost, because it's a pat on the back, and because it pads out the fact that she knows nothing about these cases. And that is a problem because, again, fraud. Again, somebody that doesn't know anything. But hey, I guess she fits that side remarkably well. Anything, let me know what you think about this stuff. There's more too. We'll talk about that in a live stream. Check out the link in the description. That's for our book as well. Industry allowed this mess to happen. They allowed these people to go out. They allowed them to do this for years. You need to walk away from them. But when you do, don't give up your hobbies. Walk towards something better. We have an alternative. Help us send a loud message with that. Thank you for being here too. Appreciate you. Into here. See you soon.